It's both French but really Latin, because in the French it means si se, but in the Latin version, where we think the voir dire actually come from, it means to speak the truth, which is what you outlined. New York has a very interesting selection process, which is slightly unique. The judge presides over it. That's not the unique part. They're going to bring down a veneer panel, probably 40 at a time, 30 at a time, depends on which courtroom the judge is going to be in and how big they are. New York's courtrooms are and he's not even in the nice courthouse where this trial is going to be held. It's going to be held there's two main courthouses. There's the one that everybody knows from Night Court, the start of that TV show, that beautiful one on Center Street. Then there's the one across the street, which is the criminal courthouse, which is not that nice. And so these courtrooms are a little bit cramped. So he'll bring up as many as he can. He's already told the people responsible for jury selection, the jury process in New York court system, how many the judge, he's told them how many he wants, brings them up. Now there's going to be there is a questionnaire with 42 questions on it, but the first thing the judge is going to do is try to do a first cut and lop off. He's got to fill 12 seats because they do the actual jurors first and all the process through that. And then they do the alternates, up to 6 alternates. It's up to the judge how many of 1 to 6 there are. And I'll talk about what happens if any of the real jurors, the regular jurors, if they can't make it one day or they get sick, what happens during trial, and God forbid what happens during deliberations, because it's not good for the prosecution if it happens during deliberations. We'll hold that for a moment. That's a cliffhanger. So he brings up these people. Judge does first cut to try to fill 12 chairs, numbered 1 to 12. Whoever finally occupies chair number 1 is the foreperson. This is not a system. The New York is not a place where, like on TV and other places, where you go in the back on the first day of deliberation and the jury picks their foreperson. Foreperson is number 1. Doesn't matter who that person is, what their background is, what their language skills are. If they can be fair and impartial and they've made it through the voir dire selection process, they've made it through the challenges that each side have. We'll talk about that in a minute. They are the foreperson. And then the judge tries to figure out, without polluting the rest of the jury or potential jury that's sitting there, who can't be fair and impartial. Raise your hands. Okay. And then the judge, without getting too deep into it, because you don't want to have somebody get up on a soapbox and start doing a pro-Trump campaign speech or an anti-Manhattan DA speech, you sort of figure out who you can pick off right away. Boom, get them out of the room. Literally, get them out of the room, and everybody moves up in the chairs. And then the judge says, now it's time for the questionnaire. And the judge will do a questionnaire, and the results of which, remember, this isn't for people that lost track, this is an anonymous jury because of Donald Trump's bad behavior, misconduct, attacks on jurors and everybody else that participates in the criminal justice system. Just as it was an anonymous jury for E. Jean Carroll twice in that case, and the one in Georgia is going to be anonymous, all because of Donald Trump. That means the lawyers and the lawyers for each side know the names and addresses and backgrounds of the people, but Trump doesn't and won't. He's been barred from that. And we won't know what they look like or what their demographics are, nor will sketch artists, because that's all we got in New York. We don't have TV, we don't have audio, we don't have YouTube. I was jealous in Georgia to watch every minute of everything in Georgia. We don't get that in New York. You and I and Karen are going to have to report from either Karen and I getting in the room one day, which I know she's working on and I got a way to get in, or we have to rely on other people that are in there that we trust that will give us the reports, and then we can do our own analysis. So now the judge goes to the 42 questions. Who here who likes the Proud Boys? I'm not kidding. These are some of the questions. Who likes the 3%ers? Who has a MAGA hat at home? Who watches their news on MSNBC? Who gets it from Fox? And everybody like you and me, they're picking a jury. I use a giant piece of oat tag, like a big, like cardboard that I've sketched out with the jury box. And I start taking my notes. And then when that's done, that's information gathering. That's the voir dire, if you will. Then it's turned over to the lawyers, prosecution first. And in state court, they're given a wide latitude, a big berth to ask these questions. In federal court, that's why they pick a federal jury like in 2 days. It's really run by the judge. Very little, you can ask very little in voir dire as a lawyer. State court, it is a free-for-all. There's case law that says that everybody has the right to get to the bottom of finding fair impartial jurors, and you can ask what you need to. So you try your case almost like you're opening, and when you get that chance, and you can ask. The prosecution goes first and starts asking questions either collectively, who here, has a MAGA hat at home? Raise your hand. Okay, you write it down. Then you can go specifically, and you do follow-ups. Okay, Mr. Garcia, Mrs. Goldberg, Mr. Jones, you said you heard, but I saw you react, and you interact with them. It's a way to start building credibility as a trial lawyer. It starts then. It doesn't start at opening. You're building your relationship with the jury as a lawyer then, both defense and prosecution. They're done. They put their case through. They did a little bit of their opening statement. They've asked their questions. They've taken their notes. They know who everybody is. They know name, rank, and serial number, age, profession, occupation, educational background, where they live, and they know those. And then they get this other stuff out. Then the defense stands up, does the exact same thing in their own way, educating the jury in their own way while also getting information. Then that's over. That period of questioning the jury is over. And now we're up to the challenges. First challenge is for cause, meaning this person is obviously incapable of being a full and fair juror. They've been on the Trump payroll before. They used to work for the Manhattan DA before. They know the witnesses. They've seen Stormy Daniels perform somewhere, whatever. That's usually a for-cause challenge. The judge will lop them off right away and remove them from the jury box. Okay, you get out. The next people in line move up in the numbered chairs. Then we go prosecutor first. We go to what's called peremptory challenges. In New York, you get 10 apiece in a criminal case. So you get 10 for absolutely no reason or good reason. You can just get rid of 10 people. And then the defense goes and does the same thing as you keep moving people into the box, right, to fill it. That's why this is going to take a week. This is not going to be, if anybody thinks it's a Monday event, there's going to be lots going on that you and I and Karen can report on about stuff that happens when the jury's not around and motion practice that's still going on, until that plane takes off for the actual opening statement. But jury selection is going to take a minute. We'll be able to report on it as best we can about the results. I think later in the week, maybe even rolling them the following Monday, we'll have a jury. We'll have to see. Now, once the peremptory challenges are done, the only thing you can't do, just to answer a question that'll come up in the chat, the only thing you can't do is you can't use your peremptory challenges to get rid of all the women, all the Black Americans, all the Hispanics. You can't target ethnic groups because then there's a challenge to that. And the judge can say, yeah, I don't think that's the right, put them back. And there's a whole process related to that. Once the peremptory challenges are used, 10 apiece, and the four causes are used, you've got your 15. And you can't, there's no backsies. Let's say you use 7 out of your 10. You can't go, oh, I want to now get rid of 3 and 8. Done. You're done. Those are your 15 locked and loaded. They get sworn in as the jury. We start the process all over again with as many alternates as the judge is going to allow here, which is about 6. Little quirk of New York jury selection and the alternates I want to talk about, and then I'll turn it back to you, Ben. The alternates unlike in some other court systems, they know they're alternates, but they also are they're like on the bench in a baseball team, and they know they could be put in at any moment. Center fielder pulls up lame. Oh, Bill, you got to go in, go. So they got to take notes. They got to participate. They just don't ever get to deliberate if they're not needed. But if they're needed, somebody gets COVID, something happens, something bad happens in somebody's life, and they can't go to court anymore, then they're off, and not temporarily. It's not like the juror just steps in for a moment and then he comes back out. I mean, that juror is off, an alternate comes in. So that's why you need 4 or 5 or 6 for a 6 or 8 week trial, which is what this is estimated. That's fine during the trial process. The exit and entry of new jurors happens all the time. I've never been in a trial longer than 2 weeks where we didn't lose a juror at some point. Now, you go to deliberations, which is the trial's over 6-8 weeks from now. And you still got, and we say, thank you for your service, Mr. and Mrs. Or whomever alternates. And the jury of 15 goes to deliberate. Somebody gets sick, dies, injured of the 15 during deliberations. You don't go with 14. and you can't pull an alternate unless the defendant agrees, Trump, which means it's an automatic mistrial. We lose one of the 15 during deliberations, it's a whole new game. It'll be a mistrial. Judge Trump won't agree, and we'll be trying this case again 3 or 4 months from now.